the cloud. Okay, so I'm Thomas F. Coleman, and I'm legal director of Spectrum Institute. And with me on this Zoom call is Debra Bookout from the Legal Aid Center of Southern Nevada, and she is the lead attorney for their Guardianship Advocacy Program. And today, the purpose of this call is to learn about what the attorneys do in that program for a typical case involving a guardianship of the person or a guardianship of the estate or both, from the time the petition is filed and they get notified until the time a case is dismissed or the petition is withdrawn or an order of guardianship is entered. And then also what happens subsequent to what follow-up is done after an order of guardianship is granted for the life of the case. And so I noticed that they have this wonderful training manual, and in it, there's a chapter 3 that says handling your guardianship case. And there's kind of a step-by-step approach, which, is appears to be a wonderful checklist. And it would be really helpful to us when Debra starts presenting to find out what's actually done in reality. I'm presuming that probably some of these steps are easier than others, depending on the complexity of the case and so on. But anyway, and then also as observers today on this call, we have John DiPietro, who's a research associate with Spectrum, and Ben Dishian, who's a legal intern from Loyola, who's working with us on this funding and fees project. So with that introduction, I'm going to turn this over to Debra to tell us about what the attorneys do. And I think there's 14 attorneys, as I understand, that work in this program. But tell us the details and don't worry about getting too deep into the weeds, because we really would like to hear what you actually do from start to dismissal or order and then subsequent to order in these cases, because this will be a real eye-opener to many attorneys and many organizations and many judges that probably have never seen any advocacy of this kind before. So the floor is yours.
Okay. So we are the Guardianship Advocacy Program at the Legal Aid Center of Southern Nevada. Within that, we also have what we call MGAP, which is our Minor Guardianship Advocacy Program. We operate exactly the same way, except MGAP represents minors and GAP represents adults. So the way it works here in Nevada is, as soon as a petition is filed, the proposed protected person is entitled to counsel. So the first thing we had to determine is, how do we know that there's been a petition filed? And then what steps to take after that. So we work with court administration, their IT folks, and their compliance office. And we came up with a system in which they notify us the following day that a petition is filed for either minor or adult. And it looks like the list I get looks like this. And it's just the case numbers for guardianship cases, whether minor or adult. So the following day I get that list, I open it up, we start doing our conflict checks. I review them, determine what they are. If it's a request for a temporary guardianship, which is a guardianship that can be granted with basically no notice to anyone. If I see that there's a request for a temp, I will immediately reach out to an attorney to get on it. And I send all the minor cases to our assistant to start looking at those conflicts, because those are a bit more extensive. For whatever reason, we have more conflicts. I generally don't do the conflict check for the adults until later, because we don't seem to have as many hits. I gather those case index lists for the week. The following Monday, we assign them. So all of the minor guardianship checks, conflict checks have been resolved at that point. I send out a list assigning a case to all of my attorneys. So that's 14 adult guardianship attorneys and 4 minor. Their assistants immediately start opening the case. That means downloading all the pleadings from the court system, asking for confidential documentation. In adult cases, it's usually the physician certificate that should be attached with the petition. And it could be some other medical records or other personal records that are attached. There's a requirement that confidential information is filed in every case to identify both the protected person or proposed protected person and the proposed guardians. So we gather those documents, we open up a case in our case system, and we open up a case in our document system on our computer drive. So then the attorney will get a notice. Oh, our assistants always also look for the physician certificate physician who signed off on it, or the facility that issued it, to request those records so that we have the most recent medical records where the physician or whoever signed it, it's usually a physician, determined that this person needs a guardianship, because that's what is required, or that's what the physician certificate contains. There's a lot of information in there, and one of them is a determination from that person whether they need a guardianship or not. So we want to look at the medical records supporting that decision.
So that's a clerical function of just requesting it. You don't need an attorney for that. You delegate things that can be done by a clerk to a clerk for efficiency and cost savings, and they get that process started.
So part of the process that is started with the assistants is they create an order appointing counsel for legal aid, identifying the attorney. So each case gets their own order with their own attorney. Within that order, we've added a lot of language that gets us access to a lot of things and a lot of documents. It gets us into facilities. And we put in there, and the court signed off on it, that we should have these medical records whenever we ask for them. And we have convinced everyone so far that we should get them for free. So this order, it's about 2.5, 3 pages. And it is really, our
key
to
the kingdom.
And it facilitates it just facilitates our ability to know our client, to get prepared to interview our client. It's the thing that gets everything started. And that gets submitted by our assistant. I think both of the guardianship judges, now we have 2 judges, allow us to submit those via email. So we can get the process going really quickly. As soon as it's date stamped, we can go out and start talking to our clients.
I love this part of the order, because in California, it's just a 1-page, 2-sentence order that just appoints counsel, and that's it. And it was interesting. Last night I was dreaming about a more extensive order that would authorize the attorney to do this, that, and the other thing. And so here you are. My dreams have come true already. Yeah.
We've expanded it over the last few years. And it has been really important. When we first started doing this, we had a lot of resistance from facilities, strangely. Of course, hospitals not wanting to share medical information. So we've got some HIPAA release information in there. So it's really something that it's sort of it's an evolving document. It's not static because of what we've learned and in terms of our needs for our clients over the years that we've been in this program, which that's not very many years, actually. The legislature enacted a law that required mandatory appointment of counsel in all guardianship cases in 2018. So it's only since January 1 of 2018 that there's been counsel required in guardianship matters. So since then, this document has grown, and it's been invaluable. When I first started doing it, we had maybe a 1-page order, Tom, and I would just still hold it to the facility and say, "You're violating this order." So we don't have the pushback there. We occasionally get a facility asking, "Well, who's going to pay for this?" And I'm like, "I don't know. They're indigent. You're going to have to figure it out. We shouldn't have to pay for it." We have a lot less cooperation from banks and other financial institutions, but the hospitals and doctors' offices have been pretty easy to work with. It's just a request. We have a form that our assistants created and our advocates created. We just send it out. So that record collection happens almost immediately when a case is open.
Yeah.
That when all of that is done and the case is ready for the attorney to review, the assistant will send the attorney an email that says the case is ready for review. In our case system, we will include any family members, any other folks identified that we might want to reach out to talk with, to interview in terms of preparing to interview our client. My practice is usually just to review everything, and then speak to the client first. A lot of other folks might want to talk to the guardian first. They might want to talk to family members. I tend to do things a little bit differently, but that's the system, and we have that information to work with.
Let me ask you this, on the proof of service. Do you check to see if all the relatives, I mean, at this point, you really don't know who all the relatives are. The petitioner has, I suppose, said that they've served the necessary relatives within whatever degree. Do you cross-check that to make sure that everyone who's...
Yes. So when we first get a case, even though it's assigned a week later, oftentimes the proof of service, it hasn't been filed yet, which is not uncommon. So we have a checklist, a procedural checklist, and some other things that most everyone uses. I'm not really sure if everyone uses it, but I think they do, where we check off, okay, has there been service on the client? Has there been service to the relatives within the second degree of consanguinity, which is required here in Nevada? Is there a physician certificate? Is the confidential information filed? And on and on. And so that is something that's part of the initial review. It isn't necessarily going to be finished until the citation hearing, which is the very first hearing. If at the citation hearing, there are missing procedural documents, that's one of the things that we might raise as an objection to the guardianship, right? That it's procedurally defective and the court can't grant it, right? So yes, that's a part of our process of review.
Okay.
You'd be surprised how many guardianships are avoided because of the procedural failures. The big one is the physician certificate. You don't get anywhere without it, right? You can get to the citation hearing, but you're not going to get any further. So we have all of that. We do the review, and then we go out to see the client. Some attorneys might have spoken to the guardian or the proposed guardian in depth. Some, if we get our medical records in time, we'll have an opportunity to review those before we go out. We might have spoken to family members before we talk to the client. I tended to want to talk to my client before I talk to anyone else, because often the proposed guardian or the family will say, oh, they can't really communicate with you.
No, right.
Right. And then you get out there and you're like, well, I don't know what they're talking about. So I don't want to have any preconceived ideas about my client's abilities to communicate. So it's my practice, and probably others, to talk to meet the person first, come up with my own idea about how they can direct me or whether they can direct me, and then maybe get some background information from family.
Now, when you meet them, I assume you're trying to meet them where they live. Do you try to, or do you communicate with them in a setting that is confidential and without undue influence looming?
We try. Yes. So in the manual that you referred to, we have this chapter 3, the ideal client, right? Where you can have a relationship with your client, where you can develop the attorney-client relationship with a client who has full capacity. That's kind of the ideal. The reason that we wrote it that way is because we should presume that we have a client who has the capacity to direct us. So if we do have that ability, we should do exactly what we would do in preparing for any other kind of case. So that's your ideal sort of guideline for how to prepare for a case. Unfortunately, because this is guardianship, it is the exception that we have a client who really can communicate in such a way where all of those things can be checked off the list. But we go into it assuming that we're going to have some ability to take direction from the client. Under the professional rules, we are obligated to represent our clients with diminished capacity in the same way that we do our other clients, to the extent that that's possible. So one of our main goals in the first interview is to determine what exactly that looks like. What is what exactly is our client's ability to direct? And so, that's kind of what we're gearing up to look for, and that we may not even discuss the guardianship, right? That may be on the second interview or a follow-up interview or something like that. So, but we work really hard to determine whether we can take direction from our client. And sometimes we determine that we can take direction on some issues, but not others. There are some issues like who they want to be their guardian, who they trust with their money, where they want to live, that doesn't require a complex thought or cognitive process that guardianship and understanding guardianship does. So we've gotten really good at that. It's not necessarily easy. And it certainly wasn't at the beginning, but we've gotten really good at sort of making those determinations. We always err on the side of, or try to err on the side of being able to take direction from our clients. But sometimes it's just not possible. When that happens, when we've made the determination after an interview that our client is not able to communicate with us, or is in a vegetative state, or simply has no capacity to direct in their guardianship proceedings, then we remain in the case and we advocate for their rights. Their statutory rights under the chapter, their civil rights, their constitutional rights, whatever rights are at risk, we advocate for that. It could be as simple as opposing fees that are unreasonable. Our client has the right to not pay unreasonable fees to their guardian or their attorneys. So it could be something that simple. It could be a bit more complex in terms of like a suitable setting for them. They have a right to a suitable setting, and on and on. So so that's the first thing we do, is interview the client. We might have spoken to the guardian. We might have to speak to the guardian's attorney to get information about, setting up an appointment if they live at home. When we were out in the field, we're getting back into it after the shutdown, but when we were out in the field, we took great pains to make sure that we got our clients in a setting where we could have a conversation with them without undue influences, without somebody listening in, without that, someone wanting to provide direction for our client. Unfortunately, some folks are hostile to that. And we just, deal with it. We usually can just say, well, here's our order, and the court's appointed us. So we don't really have any, we go, can we tell you? But it happens. But we work really hard because we're all attorneys that have been in practice for a while. We understand the importance of the confidentiality and attorney-client privilege that our clients have. So that's important to us, just like it would be with any other client. There are times when our client doesn't want to be alone, and we have to honor that. So it became harder, extraordinarily difficult, if not impossible, during the shutdown, because we had to have these interviews with like a staff or social worker or nurse holding the phone or the laptop or the iPad to have that interview. And it was awful, and we hated it. And I don't really have anything other than to say than that it was just extraordinarily stressful for attorneys to have conversations with their clients in that settings. Yeah. We're getting back out there as things open up and as we become more vaccinated and our clients are vaccinated, and we can determine the household and the safety of the household. We are seeing our clients now outside the home, so that helps with privacy. But in the old days, when we did this more often, it was a bit easier to accomplish. All right, so we interview our client. If they can direct us, we prepare, just like any other case, for the citation hearing. And we present their objection or their lack of objection to the guardianship at that time. That's the hearing where the court determines whether to grant or deny the guardianship. If our client opposes, and we've had an opportunity to draft a written opposition, we've already done that by the time we get to the guardianship, the citation hearing. Depending on the circumstances, if it's an opposition because procedurally the case is defective, it won't go any further. The court will deny it dismiss it without prejudice, and they can refile. Or if it's a matter of two different proposed guardians, competing petitions, and our client has a position on who they would prefer, We will advocate for that at the citation hearing. If the court can't make a determination on the pleadings, we'll set it down for an evidentiary hearing. Our cases are usually not set for evidentiary hearing on the issue of whether a guardianship is needed. There is usually sufficient evidence in the record, and if we don't object to it, but someone else does, that they have to present other evidence, right? So if our client doesn't object to a guardianship and some other objector says, well, they don't need a guardian, well, then we might get an evidentiary hearing in that circumstance. And then we, move forward in the hearing like we would in any other case.
So let's back up from the citation hearing and talk a little bit about how you, here in California, the doctors, the capacity declaration is on one issue only, medical capacity. There is no other affidavit or declaration by any professional required other than for medical capacity. So the petitioner can allege this and that and the other thing in the petition and supporting documents, but all that's attached is a medical capacity declaration. So now you get the medical records, you review them, you can tell a lot from that, obviously, about their medical capacity. But what about the capacity in all these other areas? Because they might be losing, their right to make decisions about, social decisions or sexual decisions or marital decisions and all of that. Do you have any experts appointed routinely to evaluate their capacity, or does that come up when there's a major contention around their level of capacity or competency?
So it would only come up, we don't have experts we rely on sort of routinely. It would come up if we're opposing the guardianship with respect to the need for a guardianship.
Right.
So one of the things that we do when we first interview a client is if we determine whether they can direct us, which is an evaluation of their capacity. We often can avoid guardianship with less restrictive alternatives, which we also always look for in that first interview. Is this really about my client forgetting to pay their bills? There are a lot of services that you can look to provide that support without putting someone in a guardianship. Is it just about medical decisions? Is it about social? In Nevada, the guardian really doesn't have authority to make decisions about our client's social life. It's nowhere in the statute. It's really two things. It's finances and medical decisions. And the medical
and what residents too, I suppose.
Well, and under the sort of the medical side of it, the guardianship of the person, that would be like residence, placement, room and board, education, that sort of thing. So it's kind of a bigger umbrella, but not anything social. They don't have any authority.
Sexual?
No. Unless they can, our clients can get married in guardianship.
Okay.
And we also have a Bill of Rights in guardianship. Yeah. So, all right. So going back to the certificate, there was an old form that was used before we got involved and had a commission to work on rules and things for guardianship. And it was crappy. It was limited. It was checking off boxes. It was putting a diagnosis, which is always something as vague as neurocognitive disorder, right? What we did is pushed for a more extensive needs assessment, which would require the person signing to actually spend a lot more time understanding how capacity affects this person's ability to make decisions. So it's about 10 pages.
Wow.
And so I can share that with you along with the order of appointing counsel. And what it gets to is it's a better picture of the client. Is it really that the client has physical incapacity, right? Maybe they're not capable of all their ADLs, but they actually have capacity to make decisions because they can communicate and process information.
Yeah.
Or is it that they don't have the capacity to write a check anymore, or they forget? I mean, it could be. It just, there's so many different.
I'd love to see that, because now, does it ask the doctor to rule out the possibility of medications or some curable or treatable medical condition that's causing the cognitive impairment?
I don't think so. I don't think
So,
so.
so how would anyone know if it's maybe medications that are causing it, and if they were changed, that the person would improve?
I don't know, except that it tends to be us who figures this out.
I see. Okay.
So a perfect example of a medical condition that affects someone's capacity, I'm sure you've seen it, UTIs. Every single client I've had who had a UTI,
What's a UTI? Oh,
urinary
okay.
tract infection, presented as if they had a cognitive problem.
Wow.
Every single one. And it's happened in my family. You give someone medication for that, there's a little bit of a lag time. They still seem loopy and out of it. And then as soon as they get better, and it's just the antibiotics working, that condition has been lifted. We've had a handful of cases where the guardianship was going to be granted, and it really was a medical condition.
But you had to do, you had to.
And we'll look for a UTI. I look for a UTI now.
Okay.
So, but if we're not, if we weren't cognizant of that, I don't know that anybody else would be, to be honest. And I don't know that even the doctor signing off on it would care too much about it. It's not his problem. In the moment, this person doesn't have capacity. Yeah. So that's a really good question. And I think because we work with our clients, we see our clients more than once. And we're able to sometimes like, okay, something isn't quite right here. And then we can do a little bit more research, talk to the social workers, talk to the nurses, look at the medical records a little bit more closely. And sometimes like, this doesn't seem right. And now we're becoming more familiar with medications involved, and, Ativan is for agitation, and what that does. It dopes people up is what it does. Right.
Right.
And sometimes, we wonder if our clients are over medicated, and we can start asking questions, and we can push back on the guardian. But nobody really is doing that work except us. You. And so I don't really know the answer to the question at a citation hearing, who's really looking out for that, because it's not in the needs assessment. And it certainly isn't something.
Sounds like maybe that the needs assessment of the doctor should be changed. What if the person hasn't had a physical for 3 or 5 years? They don't require an updated physical before
the citation?
Yeah.
No, as long as a physician signs the certificate, that gets them in the door. Now, we've argued that how can the person who's only spent 30 days with them and 2 visits, the psychiatric visit, right? The consult they brought in, when the person presented for some other medical problem, how do they possibly know anything about this person? Yeah. So we will often, and I actually had a case where I grabbed and ordered the medical records from the physician that saw my client on a regular basis. And not once was there a notation of concerns about capacity, but suddenly they lack capacity with some new doctor who doesn't know anything about them. And that went a long way to getting that person out of guardianship. This was an after the fact case, because we only started doing this in 2018. So I don't know how that would show up, how a needs assessment or a physician certificate would cover those things, other than to simply ask the question, could there be a medical condition or medication that is affecting capacity? And right now, I don't think that question is in there. Okay. To be honest, I do not think that the doctors would answer it truthfully.
Right.
In part,
it requires work.
Right. In part because oftentimes the physician who signs the certificate may be the consult that doesn't really know anything and only cursorily glanced at the medical records. It's usually the psych that comes in. He's not necessarily looking at the medical records, although they should. So, I don't know that it would be that helpful. I wouldn't trust it.
So no, when you say this physician certificate, there's like, I see like 3 different types of doctors. You've got the primary care physician that the person normally goes to. Then you're talking about some consult physician, and then you're talking about some psychiatrist or psychologist or whatever. Who is it that actually signs this document that's the driving force behind the petition?
It could be any of those people. It could even be a nurse.
Oh, wow.
Yeah. So in our statute, it is a doctor, a physician, not a type of physician, not the primary care physician, not the emergency room doctor, just any physician, or any other person the court is okay with. Our courts have gotten, probably because of our objections, have gotten a little bit more demanding of the petitioner in terms of the physician certificate, and they really want to see an actual physician's signature, someone who has hopefully the skills to, assess someone's capacity. But we all know that's not necessarily the emergency room doctor or the person treating the head injury.
Yeah.
So we get a lot of our cases are filed through the hospitals. And
Okay.
and so often what you'll see is the team for that particular, what was presented to the hospital, the condition that was presented at that moment, are the folks signing off on the physician certificate. If it's a family member, if they can get the doctor to give them this document, and there's HIPAA, of course, it could be a primary care physician that signs off on it. I'm trying to think of other.
Speaking of relatives, what type of information do you actually talk to ancillary relatives? Somebody makes a phone call to them or an email or specifically asked for their opinions or their observations?
So we tend to not ask for their opinions. We ask for information about our client. We also we all do it differently, but we have like a form letter that we send, which can be turned into a form email. Many of us prefer a phone call. I don't. I like everything in writing. But it might be, I'm introducing myself. I was appointed to represent your brother. I understand that you were served with this. Did you have knowledge of this beforehand? I like to get a little bit of background about like what actually went on. Was there a family conversation? When's the last time they saw their dad or brother? What did they think? It just is a way to sort of flesh out your knowledge of your client.
Right.
But it doesn't really mean anything. What it often does is shed light on the dynamics within the family,
Right.
which can tell you a lot, right? So I kind of pick and choose who I want to connect with after I've reviewed the case and talked to the client, because I have had situations where we've sent out these letters, and this is someone who has been estranged from this person, and they're just flat out angry that we sucked them back in. And so I try to be choosy about who I out of the blue talk. But you never know what you're going to get from a family member.
Right.
It could be very, very helpful or really not at all. All right. So you have your physician certificate. If they use the new form, it will have a needs assessment, which is pretty extensive about, ADLs and other things. And then there will be a place for the physician to issue an opinion about whether they need a guardianship or if less restrictive alternatives would be sufficient. And then that has to be a part of the petition.
Where does the social worker come into this? How many cases is there a social worker involved? Is that only when people are institutionalized or living it? Yeah. Because it seems to me like the less restrictive alternatives component would be more appropriate for a social worker that assesses what's available in the community, what supports and services, what the person needs, and to have a medical practitioner weighing in on less restrictive alternatives. How would that doctor even know what supports and services are available in the community?
Well, they wouldn't. The social workers, the way social workers are involved here is because we force them to be, when we're trying to gather information about our clients. So, and those are usually social workers that are connected with the hospital.
Okay.
And they're great sources of information, and they do understand the resources that are out there more than most. But when we talk about less restrictive alternatives, we're thinking things like maybe a rep payee who can help with bills. Oftentimes with our elderly clients, that's kind of the first thing that goes. Well, they don't need a full guardianship. They just need someone to help them with their finances. Or maybe it's a power of attorney. Maybe their medical condition and their physical incapacities really just sort of impact their life in such a way they could really use the help, but they have capacity to engage and participate in decision making. What about a power of attorney? With that, in Nevada, we need a doctor. If they're in a facility, the doctor would have to sign off on their capacity to execute a power of attorney.
Right.
We get those all the time. You'd be surprised.
Yeah. What about the clients with developmental disabilities? Are you interacting then with service providers or service coordinators or caseworkers, or to what extent do you review, if they're in, let's say they're 18 years old and they're still in school, are you getting their IEP records,
Yes.
or records from the service providers, or interviews with service providers about their abilities and other alternatives?
Yes. In fact, the IEPs, and if our clients have any connection with our, it's called Desert Regional Center.
Right.
They just are service providers for folks with intellectual disabilities.
Yeah.
If they receive services through DRC, that's a great source of information, because those folks know better than anyone what our clients are capable of. And our IEPs, the IEPs are only as good as the person preparing them.
Right.
So that can be a source of information for us, again, so that we can better understand our client when we speak to them about what might be more suitable than a guardianship. So if we can gather this information for the citation hearing, it's something, and if our client objects, then it's something that we would, use. But oftentimes our younger clients do not object to our guardianship.
Right.
To a guardianship. What we use that information for is to continue to understand our client and their abilities, and to work with the guardian to potentially terminate the guardianship down the road, because now we have a better understanding of what their needs are and what supports might be sufficient for those needs. And then we can work with the guardian to make that happen. We have supported decision-making agreements here in Nevada too.
Okay. So let's say that you have a younger client, they're not really objecting to that. Maybe they have a preference about who should be the guardian. So is there some type of a care plan that has to be presented to the court about continuing care for the person, and where they're going to live, and what their life is going to be like, and what supports and services will be involved? I know, like in California, that's not required until the order is granted. And then the conservator is supposed to develop a continuing care plan with all of those components in it. Unfortunately, here, by the time that is done, these court-appointed attorneys are nowhere to be found because they've been relieved from the case. But since your office is on for the life of the case, at what point do you weigh in? Do you weigh in prior to the order being granted, as far as what type of a plan is in place for where they're going to live, or is it just who the guardian is, and then subsequently a plan is developed?
Our statute requires that the care plan be filed, I think, within 60 days of the grant of the guardianship.
Okay.
The way our forms are online, many of the guardians file a care plan with their petition, which is kind of nice. But I'll be honest with you, no one understands what the care plan really should be. So those care plans are not very informative. I think they're mostly kind of worthless. But our advocacy, pre-citation or post-citation, all depends on our client. It depends on what our clients can direct us about. It depends on what they want. If we have a client who, I had a client who was just deaf. That's it. That's all he was deaf. And somebody told his mom that he needed a guardianship. And I just couldn't understand this. So we got to the citation hearing, but before we got to the citation hearing, we had already reached out to different resources. I turned her on to resources who turned her on to someone else. And again, with the client's input, right? Speaking with him privately about why do you need a guardian? He lived independently, he had a car, he had a job. She helped him pay his bills. Fine, she can be the payee. I mean, well, he didn't have federal benefits, but there were options for him, lots of options. And guardianship was the absolute last thing on the list. So before I even got to the citation hearing, this was all worked out. But that was because of the client I had, the guardian who was open to it, and what my client wanted, what he wanted, and what he wanted his life to look like. So all of that depends on who we're working with, right, and what their ability to direct us is. Sometimes the care plan might be nothing more than for this next year, because there's nothing in the statute that says that the care plan has to look out like a year, 2 years, 10 years. It's just, this is sort of the immediate plan of the future, is to get our clients on benefits. Oftentimes that's like the goal of the care plan, which is fine. And it does tell you a lot, but it doesn't give much more than that. If it's a younger kid or younger client, sometimes it might be to finish school, if they're in the extended school program, to get them services through DRC, to get them job training so that they can at least work some kind of job. And that's very helpful, because then we can talk to the client about what they really want. Or so it just depends on the client, and of course the care plan, which most of the time isn't that informative. Okay, but it's required after the fact, not before.
Okay, now Barbara was telling us, Barbara Buckley, who heads the Legal Aid Center, when we spoke with her in our interview, she was telling us some statistics. So it maybe you could, from your perspective, like, your advocacy seems to have an impact on outcomes as far as cases dismissed versus orders granted, maybe dismissed because the person was deaf and it wasn't needed to begin with, or because you worked out less restrictive alternatives that people agreed to and the court agreed to, or whatever. She seemed to indicate that, there was a significant percentage of cases where the petitions were dismissed for any of those reasons. Mm-hmm. Is that the case?
Yeah, I can give you the percentage of cases denied or avoided, which is our outcome code. Yeah. Give me 1 second. I had it pulled up.
Because while you're looking for that, here, like in Los Angeles County, from my review of things, it appears that probably 95 to 98% of the petitions are granted. So it seems like nothing, the role of the attorney is to expedite the case toward, making it happen.
Plenary guardianship.
Yeah.
Well, we have, and of course, it's hard to get a real number because of cases coming in and cases closing out that might have been filed 3 years ago. But in terms of guardianship denied or avoided, that's something that is a code for it never getting past the citation stage. Right. Or even getting to the citation. That's 25%.
Right. So that's a significant percent. The other thing is, with respect to terminations in Los Angeles County, termination proceedings are so rare that they're almost unheard of. And that probably is because the attorney walks away, the court-appointed attorney walks away when the order is entered. And then and nobody is really, the court investigators are overburdened and they're like kind of checking off boxes and going through the motions. They're not really looking deeply about termination, and and especially if there's any money involved, the conservator is not looking to terminate, especially if they're making money off of it. So for all of various reasons, the system is geared against terminations. And I was informed that you handle successfully a very significant number of termination proceedings.
Mm-hmm. I can tell you. So this was for 2020. Um, all right. We have two types of outcome codes for closed cases: termination due to death, and there's other codes within that. Termination for cause.
Right.
Cause would include the client regained capacity, or we identified alternative support, or they moved. What else would be included? I think that's pretty much it. Okay.
Yep.
Let me tell you what that is. That would be, where is it? Okay, so that's 25. I think it's, oh, this seems really high, 42%.
Yeah. So,
Yeah.
I mean, compare that to like 1% or 0.01% here. I mean, this has to do with the fact that you stay on the case.
Yes.
Now, tell us about a couple of things. The typical of your attorneys, what is their annual caseload?
So, well, it just keeps getting bigger. So we started in 2018. We have 14 attorneys. I carry a caseload of 80 cases right now. And the attorney with the most, I just recently looked, I want to say 145.
And that includes for the life of the cases?
Yes. And we would like to cap that number at 180, which means that we will have to hire more attorneys. We have slowly, over the years that we've been official, and I call that 2018, even though we were doing it before then, we've slowly been adding as the cases grow. Because we'd have to take them all, because that's what the statute says. So we think we could cap about 180, or even 200 would be manageable. But right now, I mean, we're getting up to that. That's where we are. I think the adult guardianship attorney with the least amount of cases, it's like 110 or 20.
So now,
and
do you know what percentage of, let's say, the 120 the person has, what percentage of those would be new cases that are pre-adjudication, pre-citation hearing or whatever? I suspect that, right. So the bulk of these are life of the case cases where there isn't much for you to do except every 6 months or something, check in with the person, see how they're doing, and be available in case they need to contact you.
So our policy is that someone has to lay eyes on the client every 6 months.
An attorney?
An attorney or an advocate.
Okay.
We wanted to do quarterly, but we have almost 2,000 cases in the office, so that really wasn't going to work. So we have two advocates who do our follow-up visits. So when we first get a case, the attorney is probably making multiple visits before the citation hearing, potentially visits after the citation hearing, and then the case will go quiet if it gets adjudicated. Right. And then the follow-up will be on the advocates, and they have the somehow system, because they're good at that stuff. They stay on top of it and they reach out in person.
Right. See, that makes a lot of sense to have an advocate rather than an attorney for that type of follow-up. And then the advocate will know if an attorney is needed for some reason.
So we created a checklist for the advocate. The advocate we started with intuitively got a lot more than we even thought we needed to look for. She even looks in their closet to make sure that they have clothes, because they get stolen in facilities a lot. It was something never even occurred to me. So we created a checklist, again, for the ideal client that can communicate with you.
Yeah.
And then she just observes the setting.
Yeah.
And she also will note the first one, because we have a second one, but she would note that at this visit, they had the same clothes on. So they're just really good at that stuff, but that's all they're doing, is they're just observing, and then they make a note, and she will say in her note, attorney action needed for this reason.
Okay.
Or you may want to call the guardian, something's up, whatever. Yeah. So we probably are going to have to add to our advocates, because it's just too many cases. But when there is attorney action and we haven't been on a regular speaking, relationship with the client, which happens, We may not know that there's been a change for the better, but the advocate will let us know. And then we can go and do a follow-up visit in person, which is what we do. And then we can take whatever action we think we need to take.
Right. Okay. Let's switch to attorney's fees. I understand that you do not charge the clients anything for your services, regardless of whether they're indigent or have assets. Is that correct? Yes. Okay. And then with respect to when a petitioner or a guardian has an attorney or an objector or whoever, and they want to get their attorney's fees paid from the assets of the person in guardianship, if they have assets, you evaluate that on behalf of your client, I assume. And are you evaluating it for, I see maybe three possible things. One, was the function that they did really necessary and within a reasonable number of hours? Number two, did it benefit the client in some way? And number three, what is the reasonable amount that you determine per hour for that attorney? Is it $100 an hour, $400 an hour? How does it work in terms of you evaluating what a fees are reasonable and whether you're going to oppose them or not?
So a big topic of discussion in the original Guardianship Commission that led to these legislative changes was around the issue of fees, because fees will suck up the state faster than anything else, right? Attorney's fees. So that was a big topic of discussion. The result of that was a very long, detailed statutory provision on what the court has to take into consideration in determining whether to award fees from an estate. The first thing that has to happen is that the attorney who wants to seek fees from the estate must file a notice of intent to do so upon first appearance. They don't file that notice of intent, they don't get their fees. Well, the judges don't think that's what the statute says, so we've been fighting that, but that's what the statute says. So in that notice of intent, they lay out their rate, right? And any person working on the case in their office who might bill to that case, or their paralegal or assistant, and the reason that they're necessary, which is a big problem because most cases don't need an attorney in guardianship. It's just not rocket science, right? It's not, you don't need a $500, $600 attorney. But anyway, all that has to go in their notice. What we decided to do was do some research on using the court's factors, right, about what's reasonable. We determined there's a lot of statistics out there about what an average attorney rate is across the country. Nevada is extraordinarily high. Don't ask me why. Maybe because we don't have any attorneys. I don't know. But we decided that we would use that statistical information countrywide and argue that anything above 350, which is the national average, was not reasonable. We could make that argument more specifically in a case if we knew that the estate was low, right? There wasn't much of the estate. We could make the argument even stronger if there was nothing to be done on the case, except, the client was in a vegetative state. There was no question about guardianship. I mean, what are you doing? You're just filing a petition, which is online. Right. You can fillable forms that pro-pers do all the time. So we had a lot of ways that the statute provided to object to this. So what we decided is when we see that notice of intent and it contains information that we've determined is unreasonable, like the rates are too high. Sometimes they'll have the paralegal's rate at $275. Well, I'm sorry, that's an attorney, right? Yeah. And that isn't reasonable because we have paralegal statistics that say that that's on the way high end for a paralegal, okay, depending on the years of experience. So we put an opposition together with those sort of basic arguments. When we see it, we'll file a notice of objection to their notice of intent, so that once they file the notice of intent, they can then seek fees from the court for the actual award. We've already lodged a general objection. Well, now we know the case. Now we know whether they've mitigated time, whether they've delegated tasks to a lower rate biller. and all the things that the statute says the court is supposed to look at in terms of analyzing the reasonableness of the fees. We have that information. So we have our original notice of objection, and then we can do an opposition. We argue all the time, anything over 350 is not reasonable in a guardianship, even a complex one, which doesn't happen very often. We also and we haven't won on that argument, just FYI. We literally look at line items. If an attorney who's been practicing for 25 years in guardianship needs 3 hours to put a pro forma petition together, we will argue that that's excessive. That's excessive time. And by the way, you could have let your paralegal do that. How do we know this? Because you file 10 of them a week, right?
Right.
So we put those arguments in there, and we've been successful in some cases and not others. We currently have a case on appeal that's pending. I don't know that it's been fully briefed, and then on fees, and then we have one that's just got filed on fees. So we'll see. But our statute is really very detailed about what is reasonable in guardianship and whether and how the court can award fees.
Okay, I'd like to switch to just to find out what is the average salary or pay of one of the attorneys. What's the range of pay for the attorneys on your staff?
I'm going to have to leave.
Okay, John, thank you for joining us.
Deborah, thank you so much. You're very encouraging, and your program is excellent. I'm sure we'll be looking.
Yeah, come back for more. We'd like to spread the word.
Okay. Thanks so much, everybody. Take care.
Okay.
Bye.
So Tom, I didn't know the answer to that question. So I asked our, I don't know what he is, CFO.
Yeah.
He couldn't give me a range because it's commensurate upon experience, but I don't know. I feel like you could get a range, but whatever. What he did tell me was that an attorney with 0 experience starts at 50,000.
Okay.
Which I think is high, but what do I know? I've always been in the public sector, so I don't know what real attorneys make. So it starts at 50,
okay.
And then it just goes from there depending on the experience, and it may be the type of experience. I don't know. So that's all I got.
Okay. And then also in terms of, let's say, if there ever were a typical case, I guess every case is different, but on average, do you know how many hours an attorney spends on a case from the time the petition is filed until the time the order is entered?
I don't, but I bet I could figure that out with our case system.
Okay, I would like to know that. I developed a set of performance standards of what it seemed to me a zealous advocate would do in a typical case. And, and that included, the investigation, the interviews, the review of documents, the, home visit, the court appearance, et cetera. And it seemed to range between like about 14 to 20 hours of attorney time to do all of the functions that, and this included, some functions that are not on your list. So I'm just, when I analyzed what attorneys were actually doing, especially the ones that got the most appointments for the indigent cases, they were putting in about 4 hours on a case from start to finish, which of course then pleased the court and then got them more appointments. So I would be very curious to see with the, of course, you've gotten this down to a real science now. So, even though you're thorough in what you do, you're very efficient in your thoroughness. So, and especially for an experienced attorney would probably take a little less time. But I would be very curious if you're ever able to take a look at that to analyze that. I
would not be surprised if that is close to what you came up with is close to what we do, and that would be the average. Because we have cases, of course, where there's a lot more time that's needed. The ones that need additional visits, right? Because we're just not quite figuring out what the real needs are. It may be that we on a case where they're requesting a temporary guardianship, we might need additional time with the client. So it just depends, but I would not be surprised if that's not close to what even the experienced ones. And even I would, I mean, I have to review everything too. I want to look at the medical records. I
Yeah.
want to spend time with the client. You don't want to get in, you don't want to spend 10 minutes with your client unless
Right.
they can't talk to you, right? But so it wouldn't surprise me.
And sometimes you got to go back just because they're
yes.
having a bad day.
Yes, yes.
You know, things
But
like that.
We have had attorneys go morning, noon, and evening to determine the best time. That's a
Wow.
lot of time. It's travel
Yeah.
time. It's
Yeah.
you know, so yeah, I would not be surprised.
So all of this information is going to be helpful to us because one of the things that I'm asking Ben to do is I've gathered all sorts of sources of information regarding performance standards, and your training guide is one of them, and there are others. So I've got probably about maybe 6 or 7 sources of what should be done in a case. And I want him to go through and create, a comprehensive checklist. So once we have kind of a checklist of what should be done, then we have to estimate, well, approximately how much time would it take for each of these functions? And then you can determine, the amount of time. Then you can, from that, you can determine how many cases an attorney, let's say a public defender, could reasonably handle and still provide effective assistance according to the performance standards. And some of the public defenders that I've talked to, because some of them are handling misdemeanors and juvenile cases as well as conservatorships. It's not just conservatorships. And the life of the case in these cases don't go on indefinitely like it does for guardianship in your situation. So the life of the case for each of these, a misdemeanor or, a juvenile delinquency case or even a guardianship case to the point when the order is entered, could be several months to a year, possibly. Well, some of them they have 300 open cases. So how could they possibly provide effective assistance? But I think that when we're going to be digging into this to taking a look at what they actually do on these cases. Do they even have a checklist? Do they have performance standards? And I also want to ask you on your end, are there any supervisory reviews of cases periodically to see what a line attorney has done, just to maybe 2 or 3 cases a year or whatever it might be, just to see what's going on?
So our policy at Legal Aid is a new attorney will submit any written pleadings to their supervisor in their first year.
Okay.
Well, in my case, I can ensure, one, that it looks good. 2, that it's consistent with our policies in terms of the positions we've taken on certain things. For example, $350 the rate should be capped at $350. We've been pushing for that. I think attorneys have a hard time objecting to other attorneys' fees. So I think that our attorneys sometimes get a little bit choosy about when to object. So it has to come to me. Yeah. The other thing that we do that my predecessor, Jim, I don't know if you met him.
Yeah.
Early on decided to do was have weekly meetings where we talk about issues, things that kind of come up. And when we first started doing this, it was all new. Nobody had done guardianship, well, except me, but it was just by default. It just fell into my lap. I had nobody idea what I was doing. So everything was new. And we agreed, Jim and I early on agreed to certain perspectives and policies about things. So there was before the statute, the decision that the commission made was that counsel would be an advocate, not a GAL, right?
Right.
Okay. That informed a lot of our strategy in our cases, right? As soon as we knew we were going to be an advocate, then that just made it a little bit easier, right? It was clearer what our job would be. So we, things like if our client can say, object to, maybe it's a place that the guardian wants to put them, and she can reasonably explain why, we're going to take the position that we can take direction from her on that issue.
Right.
I want everybody to do the same. So one of the things that we do in these meetings is we make sure that everyone understands that we're all on the same page. The worst thing we think could happen is that one attorney take one position,
Right.
and another attorney take a different one on the same issue.
So, okay. So now
So that's
the
one way
meetings,
to keep on top of that.
then, so that's, how long is the meeting? Once a week?
It's an hour once a week.
Okay.
Then, Tom, this is getting harder and harder to do as our group grows. When I review cases, I randomly select cases through our system and I look at everything. So I can review your case and I can know exactly how long it took you to touch that file when the assistant told you the case is ready for review. I can see when you went out to the interview. I can see what review you did. I can see that you didn't draft anything and I would have filed an opposition. I can see all that. Now
Okay.
it's random, and it has to be random because my attorneys have anywhere from 110, 20 cases to 145.
So how many of those random cases would you review per year?
For the annual review, it would probably be, if they had 150 cases, it would probably be 15.
Of each attorney?
Yeah.
Not the whole office. So you would review.
Oh no, each attorney. I review each attorney's
15 cases from each attorney. Wow.
And what I would try to do is I would try to find, well, this is what I do to myself. I would try to find new cases and old cases, right? Cases that have been sitting for a while and are quiet, cases that are brand new, so that I could get a better picture of not just what the client's doing, but again, ensuring that we're all on the same page, right? And so, for example, I might look at an old case where I knew that there was an attorney, and then I would look to see if the petition for fees was filed. And then I would look to see if I thought it was unreasonable what the attorney did.
Okay.
And then I would have a conversation and review. Well, I noticed this. What is your thinking? And sometimes the client will have told them don't object, but they didn't make a note in their file.
Okay.
Okay, we'll make a note in your file.
Okay.
So it is an extraordinary amount of work. So I'll take like every 10th case, every 15th case, just randomly. If I need to dig deeper, I will go back on my list and look at cases that were assigned within the last 6 weeks, so I could understand the prep work, the pre-prep work, and how quickly they touch a file. It's very important for us that we get on top of our cases very quickly.
Yeah.
And so that's kind of easy to see in our system. So that's what I do every year for every single attorney.
Yeah. Now, is there a complaint process in the office that a client or anybody else associated with a case could complain about the attorney's performance, and how is that handled?
We have a closing letter that goes out if a case is closed with a survey, and we have a true complaint process, which is administrative. They have to call in and ask for the form. They send it back in. I forget who it goes to. It goes to a couple of people, eventually gets up to the ED, and then we go from there.
So you actually solicit input from, who do you send those surveys out to?
In guardianship, if we get a guardianship denied or avoided, or we terminate for cause, we always send closing letters to those cases.
To whom?
To those clients, sorry.
Oh, to the clients.
Right. So those are clients who we avoided guardianship for any number of reasons, usually because they don't need one. Or we've terminated it because we've determined that there are supports that would work just as well. And we will always send out a survey and solicit that information. And then our office sends it to each department, and then I send it around to the attorneys so they can pat themselves on the back for a good job.
So no, nothing is sent out to the judge or to the opposing counsel or the guardian. So it's basically, you want to know from the client's level of satisfaction.
Because honestly, I don't care about what the judge or the other counsel.
Right.
Quite frankly, counsel for guardians hate us. We make their lives miserable. They truly hate us. And I hate having that role in the community, but the reality is they hate us about money. They're mad at us because we oppose their fees. They don't really care about the client. They'll say that they do, but they don't. It's about the gravy train that we stopped. And so, you know, we have to live with that. I'm okay with that, quite frankly.
Okay, so in closing, there's like two other things. One, Ben, do you have any questions or anything that you would want to ask at this point? No?
No, I don't have any questions.
Okay, great. And then Deborah, is there anything that I didn't ask that you think I should have asked or that you want to add before we close this out?
I was looking at your list just to make sure that it was pretty comprehensive, Tom. So I don't know that I had anything. You'd asked me about benefits. Let's see, appeals. Benefits, I can tell you. Let me just tell you.
Yeah.
Well, actually,
Benefits
a couple things I want to tell you.
Yeah.
A couple things I want to tell you. This unit is possible because of funding.
Right.
Right. It's easy for the legislature to say, yeah, we demand this, right? But then there's no money for it. That happens all the time, right? What was great about the legislature in 2017, after the commission issued their report, was that nobody was going to do anything without a source of funding. Because why? What's the point of all of that? So we got funding early on through fees.
Right.
I'm sure Barbara told you about that. You know, the ability to have a funded mandate. There's no way to express like how much easier that made our job. But because we're legal aid, we have this funding and we don't bill our clients. We don't have to answer to anyone. It's really wonderful to be able to just advocate for our clients the way we should, the way they want, what they want, you know, being their voice. That changed everything. If you're going to stick, you know, guardianship with the public defender or some other organization that does other things, it's not going to work.
Right.
It's just not. So
well, there's too much ongoing politics involved. And then there's always, you know, robbing Peter to pay Paul, and
right.
the public, the line attorney in the public defender's office reports to the supervisor, you know, to the head public defender. The head public defender is not elected like a district attorney is. So they're appointed. So they serve at the wish of the supervisors. The board of supervisors says, here's how much money you're going to get. What are they going to do? You know, how are they going to push back? You know, if they push back
right.
too hard, they'll just replace them with somebody else who won't.
Right.
So this is where an independent nonprofit agency that meets the statutory criteria to receive the appointments, it's like it would take legislation to get rid of you. New legislation.
Right. With very specific funding that isn't shared with other agencies. This is money specifically for guardianship.
Right.
So nobody can fight over it. Right. So anyway, that I just wanted to share that. I think that's what has given us an opportunity to have the impact that we have, right?
Yes.
Have had, and we have had a big impact. The other thing is we have really good attorneys. I'm always surprised at how we can recruit such good attorneys. Most of us came here with years of experience. I'm in my 30th year of practice, and I came in 2014 or 2013. I came to legal aid. So I was practicing for, I don't know, I can't do the math, a lot of years. And that's kind of the case. That's kind of the case with everyone. And some of these folks, we have litigators, amazing litigators that are working at legal aid. So most people have just decided they want to do something that has some sort of, I don't know, meaning beyond getting money for their clients. So they're quite committed to what we do. So there's that, of course. But legal aid pays our insurance, every penny of it. Every penny. We don't pay a dime for insurance except copay. Right?
You mean medical and
medical insurance? I think we have a little bit of health, life insurance. But
is there any pension plan
vision,
or anything?
dental. Huh?
Okay, is there any pension plan or anything, or?
There is a 403B matching 5% up to 5%.
Okay.
We also get a very generous vacation. 15 hours accrued every month in the first 3 years, 18 after the first 5, and after that 20. That's a lot of vacation time. And I just think it's important to note, if you want good people and they just have bills, right? How do you make the pot a little bit sweeter? For families, having our medical insurance paid for by legal aid is huge, right? They can make the sacrifices when it comes to salary because there's this benefit. So we have very little turnover. We have folks that retire from here. folks that come here after retirement from private practice. It's just, Barbara has figured out how to get good people, and that's a part of it, or the
Wow.
benefits.
Yeah.
What else? I think that was it, really,
Okay.
that I wanted to add, other
Yeah.
than that we're awesome. You should come and spend a day with us.
I know I would like to. Well, someday that'll happen, especially now that they've got from Palm Springs to Las Vegas, Southwest flies. So, it would be quick and
Yeah, I saw that.
inexpensive
Yeah.
and so on. So anyway, we've learned a lot from your program, from Barbara's presentation, from your presentation, from your resource written materials. And now it's a matter of, trying to package it in a way that we can incorporate it into our study as we're eventually going to be proposing various models that, could be options, probably at the county level, I suspect, because right now that's the way the funding for legal services for conservatorships for indigents is handled. But that's not to rule out the possibility of new legislation that changes the paradigm completely. So we'll see where it goes. But if you could send me that copy of that order that I dreamed about last night.
And a case assessment? I mean, a physician certificate with a case assessment?
Yeah.
Or
So,
needs assessment? Yeah.
those would be helpful. And then you were going to see if you could figure out about the average number of hours if you get a little bit closer. Otherwise, I think that's it. And I'm just really excited about, meeting all of you, and then your willingness to be, you and Jim to be advisors, guardianship advocacy advisors to our project, so that we can pick your brain anytime, within reason that we need to. And so thank you for everything, and
Thank
especially
you.
for this interview.
Okay. Thanks.
Okay.
Nice to meet you, Ben.
Let me unrecord or stop